Well, good morning, everyone. Again, my name is Mimi Larsen, and I have the honor today of moderating this very important panel on cumulative impacts. So let's start with some introductions here. I'm going to turn this over first to Nathan Bennett. He's the Director of Planning and Permitting at Civitas Resources. He's been working within the DJ Basin since moving to Colorado in 2016. And has been with Civitas since the inception in late 2021. He enjoys spending time with his family, attending his daughter's swim meets, and chasing trout in his spare time. Also with us today is Lauren Mercer-Gillen. Lauren is the Deputy Director for Policy at ECMC. While she's new in this role, having just come on board in March, she previously represented ECMC as a lawyer in the Attorney General's office. In that capacity, she worked on many legislative initiatives and rulemakings, including representing ECMC staff in the cumulative impacts rulemaking. Max Blair is the regulatory manager for GMT, a small independent upstream exploration and production company. Maxwell has over 25 years of experience in the energy industry, working on upstream, downstream, and midstream assets. Katie Gillen is the Vice President of Regulatory and EHS at Bison for Oil and Gas and has spent her career leading the implementation of every major oil and gas rulemaking in Colorado. And as we heard this morning, there have been a lot. With a background in air quality and environmental management, Katie is known for her common sense approach to aligning regulatory compliance with sustainable energy development. So this is a really important topic. We're going to start by setting the stage and giving everyone an overview of what the cumulative impact rules are and how they came to be at the ECMC. And to do that, I'm going to turn it over to Lauren, who will give us that presentation.
Great. Thank you, Mimi, and thank you, everyone, for having me here. It's my first time at this event after hearing about it for years, so I'm very excited to be here. I am going to try to give a 5-minute overview of the cumulative impacts rules, which is going to require keeping things at a very high level, but I'm available for questions after the panel as well. So the cumulative impacts rules that ECMC adopted are ambitious by design, and that's because the legislature gave us very ambitious and prescriptive requirements for a lot of what needed to go into them. The challenge, both in the rulemaking and in implementation, is ensuring that we can have these rules that meet those really ambitious requirements while also being implementable by ECMC and the operators. So I see the sort of dark green circle or overlap there as the sweet spot that we are trying to hit. So although the cumulative impacts rules that were just adopted this past December are a big step, we've been on a long road to get here. Senate Bill 19-181 was the first time that ECMC was instructed to regulate oil and gas with a focus on cumulative impacts, and that has just grown year over year since then to the point that we are at now. Like I said, the legislature was very specific about how we were to regulate cumulative impacts and gave us this definition of cumulative impacts, which I won't read to you in part because the screens are very small. I agree with Kathleen on that. But also, it's a very broad definition, and so that necessarily means that the rules need to be very comprehensive. The cumulative impacts rules, as I alluded to, did a lot of things. The sort of 5 big buckets are up on the slide here. First is that they set a framework to evaluate the incremental impacts of oil and gas operations as they contribute to cumulative impacts. The primary way that we are doing this is through the requirement for cumulative impacts analysis submitted with every OGDP, CAP, and certain other applications. The second component is measures to address those cumulative impacts. The rules do that in a number of ways. One I'd like to highlight are the Enhanced Systems and Practices, or ESPs we'll call them. And these are practices that are designed to reduce NOx emissions, specifically in the ozone non-attainment area. A third main goal of the rules is to add protections for disproportionately impacted communities. The rules do this in quite a few ways by increasing opportunities for meaningful engagement, and as a few of us have already mentioned today, by creating the Community Liaison Program, where we have Stephen and Jessica, who are dedicated resources to help DIC community members engage in the process in a really proactive way, in a way we've never been able to before. The rules also aim to streamline and align our rules with some of APCD's requirements, and finally sort of further bake in the mitigation hierarchy that Greg talked about earlier, which is to first avoid adverse impacts, then minimize those that can't be totally avoided, and finally to mitigate the impacts that remain. The rules were adopted in October, went into effect December 15th, and since then, ECMC staff has been really hard at work on implementation. So far, we have 4 OGDPs that have been submitted under the new rules, and quite a few that are in the pre-application stages. So permitting processes are continuing to chug along under the new rules. We've also stepped up our engagement with communities, including by the community liaisons. And I know top of mind for a lot of folks in the industry are forms and guidance. Staff has gotten all of the necessary forms updated or created, which is a really big lift that I didn't actually quite understand until I came to the agency, how much work that is. And of course, guidance. We've released so far, I believe, 4 different guidance documents related to the rules. Those can all be found on our website. And I know there's a big demand for what's coming next, which is the guidance on cumulative impacts analysis, including how to establish the area of evaluation. So sorry to talk fast. If you take anything from this presentation, these are sort of my top line takeaways. First is that these rules represent a really big change for all of us. And so I think successful implementation is going to require a lot of communication and would encourage us all to sort of give each other some grace while we adapt to this new regime. Second is that cumulative impacts analysis is required for all applications. I think there was some confusion on that by certain folks, so just wanted to emphasize that. The successful applications that I think are going to be the ones that really take into account not only the letter, but also the spirit of the CI rules. As Director Murphy mentioned earlier, cumulative impacts isn't a strict numerical standard. A lot of it is narrative evaluations and things like that are inherently a little bit more subjective. So the applications that have the least chance of folks sort of disagreeing about whether they do it right are going to be the ones that take a really holistic approach. And finally, just continue to keep that mitigation hierarchy in mind. That is it, and I will hand it back to Mimi.
All right. Well, thank you, Lauren, for that overview. Lauren, in your comments here, you noted that the cumulative impacts analysis in this rulemaking really started back with Senate Bill 19181. So I'll direct this question to everyone, and maybe Nathan, I'll start with you for an answer, but I'm curious if you can talk to us a little bit about how much of what we're seeing today in these cumulative impact rules were operators already incorporating into their planning and permitting process, because as a result of Senate Bill 19181, there was the mission change rulemaking, which required a wholesale change really in the permitting process here in Colorado. So how much of this, what we're seeing today with cumulative impacts, was already underway as a result of 181?
I appreciate the question, and good morning. In many respects, the avoid, minimize, mitigate hierarchy has always been present in how we plan our operations. With the rulemakings, both mission change as well as the most recent one, it's really formalized that process so that it is digestible and apparent to the public of what we go through. Admittedly, we invest a lot of time in selecting our locations, as well as, it takes a lot of time, I should say, to select our locations, and we're talking years, not months. And so with the formalization of these requirements, we are now able to demonstrate how we selected our location and what we're going to do to minimize those impacts to the surrounding stakeholders.
Thank you. Katie, what about you?
Yeah, thanks for the question. And Good morning, everyone. I'm very excited to be here. I think this is going to be a great conversation, and we'll each bring a very unique perspective. So Bison, I want to tell everyone a little bit about Bison you may not know. We are a private equity-backed company, and we operate predominantly in unincorporated Weld County. And we do have a few assets elsewhere in the state. But because of that, we are actually in a very remote area outside of a disproportionately impacted community. And it is very rare that we meet any of the ALA criteria for some of our locations. And so as we kind of step back and look at how cumulative impacts will affect our operations, the new area of evaluation is something we're still, I think, very much learning about and awaiting guidance on. But I think right now we're wondering how that'll affect the siting of locations in the future, and what that will mean for our development.
Thank you. Max, I know you, not perhaps as small as Bison, but in similar acreage, right?
Yeah, thank you, Mimi. GMT is also a small operator, and we're operating in an environment that's near urban development, but generally very rural. To speak to the impact of the new CI rules and how it's affected our process, I'd say, as with all operators, we've had to evolve. We've had to process these new requirements, incorporate them into our planning, and generally I'd say planning now takes significantly longer. Site selection can be an even more critical component from the start, right? Starting with a good location that meets all of your project needs and still gives you access to the resource that you have the rights to develop as an operator. We can't, as regulatory practitioners for our respective companies, we don't generally get to choose where the development's going to take place. It's our job to figure out how to get it approved and to do it successfully. The new rules, I think, do bring to the surface more of the work that has always occurred in the background within our companies to try to find those best fits. There's never, very rarely, a perfect location or perfect fit, but the best fit accounting for all of those other requirements we have to meet.
Appreciate that. And Lauren, I don't know if you have any thoughts about how it's kind of evolved from mission change to now cumulative impacts, if there are any observations you'd like to share.
Sure. I'd agree with a lot of what Max and the other panelists said, that the cumulative impacts rules sort of codify and formalize and bring to the foreground a lot of practices that have been happening since mission change. I think ECMC has long looked at site selection as one of the best, if not the best, ways to avoid, minimize, and mitigate impacts, adverse impacts. And so the alternative location analysis process has always, since mission change, been really important. And that's a big component now of the cumulative impacts rules. So it's sort of taking what we were already doing and leveling up is sort of how I see it.
All right, now I want to talk a little bit about the impacts of the air quality regulations that we've seen a lot of change and evolution over the last 5 years, really. So for operators in the DJ Basin, as we know, there's been many rulemakings to address emissions related to oil and gas operations. So with the AQCC's rules plus ECMC's attention to emissions in the pre-production phase, how were operators already moving towards adoption of some of the measures that we have now seen in the cumulative impact rules, specifically the enhanced system and practice requirements? Maybe Max, I'll turn over to you.
Yeah, thanks, Mimi. Well, I'll start by saying air is not an area of expertise of mine. Most of my work has been everything but air in my career. So it's been a learning curve for me, and certainly I have a lot more consultants working on air issues than ever before to help understand the requirements and put plans together that meet those requirements. GMT is also unique in that we're just now planning projects in ozone non-attainment areas, and fortunately we've been operating outside of those up to this point. So another level up that we have to try to achieve to be successful with our planning. Looking at those ESPs, there's a list there that we're now trying to incorporate into our plans, and a few of those I think sprung up through technological improvements, development, looking at the containerized sand delivery for frac jobs. I mean, that's a technology that's been around for 10 plus years, and it's a huge improvement over the old ways of doing business. So it was adopted pretty readily by industry, and I don't see much of a change there. I think most front range operators are using that technology. It's good for logistics, it's good for worker safety and health, it's good for the environment, and it helps get your work done efficiently. Some of the others, we just had a panel discussion just prior to this around the demands on the grid and electrical power generation. One of the ESPs is around using electric drilling rigs. That's now an expectation for operators to find a solution to implement grid-powered drilling, grid-powered production facilities, and that is not a simple problem to solve, and it won't be solved quickly by the industry. So I'm hopeful, as we've already discussed, that we're still testing these rules, and we have very few data points with just some pending applications, nothing approved yet, but there is a process built into the rules for operators to now, the burden is on the operator to demonstrate practicability of implementation of those ESPs. I think the grid power question is going to be one of the biggest challenges we face.
Fascinating. Katie?
Certainly. Yeah, I'll echo kind of some of the concerns around electrification. Obviously, we have been heading down this path for a while now, and so if you haven't seen the train coming, you should be looking. And so, I think Bison, for most of our acreage, we're fairly well positioned for electrification, and in spite of our rural development and the lack of receptors, we have adopted many of these best management practices in our operations, and so we do feel prepared, I think, heading into the cumulative impacts rules to implement many of these BMPs. I think where we may face challenges is, the elimination of tanks in our operations. While some operators may benefit from access to fizzy oil systems, Bison has more limited access there. And so planning for that change will take some time. And so we'll have to see how that goes. And then the other thing I'd like to mention is, Bison, while the core team has been around in the DJ and operated since 2015, Bison 4 was formed in February of 2023. So we are in a very unique position, having not had 5 years in advance to plan our locations. And so navigating the long lead times on the planning side will also be a challenge. And so I think with tariffs, maybe this is a welcome slowdown, even though we hope things will turn around, but it'll give us a little bit of time to step back and do the additional planning that we will need to do to meet some of these new requirements. I also kind of want to touch on some technological advancements that happen in the industry that really make a difference on cumulative impacts, and one being, operators like Bison and some of my counterparts sitting here are now drilling 3-mile lateral wells. I think most of the wells you see in the DJ are actually 2-mile laterals. And so what this means is, fewer surface locations will be needed in some instances to develop those minerals. And I think that will have a pretty significant impact on energy development in Colorado. The other thing, Bison set a new drilling record in the basin for the fastest drilling time. I think it was 612 feet per hour. And so we're seeing reduced time on pad for drilling. And so we're excited about those technological advancements and how that will reduce impacts for new development.
Thank you. Nathan?
Thank you, Mimi. Our Civitas' portfolio is somewhat unique in that we have acreage in rural Weld County as well as within the urban corridor. And so many of the enhanced systems and practices that are now contained in the rules are things that we did as part of our urban operations. One of the challenges is going to be expanding those ESPs into our more rural areas for the reasons that my colleagues mentioned here. First and foremost being electrification. Secondly, some infrastructure that may exist closer to the city of Denver that does not exist in the rural extents of Weld County will pose some challenges as well. Katie's mentioning of technological advances is extremely on point. It's kind of a double-edged sword as we've experienced in that as we've tried to consolidate locations to reduce our footprint within the communities in which we operate, our well counts have gone up. To be able to develop that same mineral acreage that we could with multiple pads via one. And that does pose challenges every now and then on the permitting side, particularly with the air permits that are required from time to time as it relates to source engines and things like that. The longer you're on a single location with your drilling operations or your completions operations, the closer you may get to some of those thresholds that have been established by CDPHE. And so you really have to contemplate how you choreograph your operations so that you're not unduly burdening the communities with long occupation times, but you're also being cognizant of what those permitting requirements may be as it relates to air.
Fascinating. So I now want to shift the conversation over to community engagement, because as we know, the rules also focus heavily on how operators reach out to communities if they're going to be within a certain vicinity of humans and schools and things like that. So, within the rules, there are specific requirements for outreach and engagement, specifically with communities that are disproportionately impacted. Can you describe to us how you've been approaching community engagement before the cumulative impact rules were adopted, and to what extent these efforts may have changed as a result of these rules? Nathan, I'll start with you.
Certainly. Thanks, Mimi. So Civitas' preference prior to the recent adoption of the cumulative impacts rules was to always engage our stakeholders one-on-one. We felt it was more meaningful and personal to sit down with a resident or a household and have a conversation over their table, explain what we intended to do, how long we were going to be there, and answer any specific questions they may have to the best of our ability. A couple of years ago, there became a need to be more public-facing with some of our projects, and so we started implementing the use of project-specific websites. Post information on those websites that were updated in real time, so those constituents that we had talked to over their kitchen tables or maybe their neighbors could go to a point of reference and understand where we were in the project and what our plans were. With the advent of, or the implementation of the cumulative impacts rules in December, the notification radius is now expanded, and there are additional requirements to engage communities and nearby stakeholders, which will, I think, move us to more of a town hall type engagement, potentially virtual engagement, whether it's through Teams or Zoom, to make sure that we are getting that information to the folks that are interested in receiving it and answering any questions they have. I think undoubtedly we will still have that need and want to meet with folks individually to ensure that their questions and concerns are being addressed and that they know who we are. So if there's ever any questions, they can pick up the phone and say, hey, remember when we talked, in the kitchen 6 months ago, I thought I heard you say this, but now it's something different. Can you help me understand? And so it's very much a hands-on approach and one that I think will continue to evolve as we continue to move through this decade.
Max, what about you?
First I'll agree with all of that. It's what you guys have done to evolve as the requirements have changed I think is worth noting. And my approach to stakeholder engagement, community engagement has been similar and has evolved as well. I've got years of experience sitting at kitchen tables, meeting with folks one-on-one, and it's one of my favorite parts of my job, to be honest. Actually getting to know people and hearing their concerns firsthand, and hopefully having answers to those concerns to demystify the process and to clarify maybe a misunderstanding of how the process works or what protections and rules are in place, what we can and can't do on a location. So that's still, I think, a very useful and effective tool. The new rules under ECMC at the state and many new rules at the local level, again, have simply, they've created new requirements, new points that we have to hit in that engagement. But the sky's the limit on what we can do, what effort we can put forth to reach out and engage with those community members. So I'm still a one-on-one kind of guy to the best of my ability, but we will learn from our colleagues, and we'll hopefully find ways to reach out that are effective and also hopefully efficient, and ultimately lead to better education of the process for the surrounding communities.
Excellent. Katie.
Well, I will start. We are out in the middle of nowhere. And so we haven't had a tremendous amount of urban development at this point. And so there's been a lack of community interest in our operations to date. And so I think right now Bison is just observing and learning from other operators how to best engage with the community should we enter more urban development. Also would like to understand the new role of the community liaisons and welcome. We look forward to working with you in the future. So.
That's a great segue to a question for Lauren. So Lauren, can you talk a little bit about how the liaisons are going to help supplement, or what will that role be to assist perhaps in operator outreach?
Thanks, Mimi. And yeah, so I think that the community liaisons and the new approach in the cumulative impacts rules, I see for ECMC as changing from a more reactive posture when it came to community engagement to really proactive community engagement. By statute and rules, the liaisons are to be dedicated resources to residents of disproportionately impacted communities. And I see that as really helping community members meaningfully engage in the permitting and regulatory processes. As part of that, our liaisons are already having conversations with operators about their pre-application community meetings and their community engagement plans. So the liaisons are first and foremost a resource to the community, but I think I can safely say they're also a resource to operators and even to local government as far as it comes to that interaction. Especially because the pre-application community meeting and the post-completeness community meeting, those are two brand new requirements. We've never mandated that before. And there are certain provisions in the rules about who needs to be invited and how you need to send out those invitations and things like that. And so we did issue guidance on those points just this past week. Our community liaisons were the primary authors of that. But they're also your first point of contact when you're setting up those community meetings. So you can talk about things like where it should be held, how you can make sure that it's accessible to members of the community, whether that requires transportation or translation services. So we're hoping to really have an open line of communication between operators and our liaisons to facilitate that communication.
That's great. So cognizant of time, we think there might be a fair number of questions for the panel. So I think maybe we'll turn it over to questions now from the audience, if there are any. If not, we do have another question that we can certainly ask and engage in more dialogue. But let me open it up for questions, and we'll see where this may take us.
You talked about the spirit, not so much the letter of the rules, but maybe the spirit of the rules. I see. Seems like small operators right now are they're under the same burden as a larger operator. So I heard having to hire consultants and things like that. When that fee that was talked about in the earlier discussion, the financial discussion, that's basically a tax that is put on the production of oil and gas. Is there any contemplation of not treating, or maybe making it easier on smaller operators? Because they're being treated. It seems like that might be for compliance to stay in the spirit. It'd be easier if they had if they weren't treated the same as the larger operators. Is that an interest at all, or is it just one blanket approach?
So it sounds like maybe a more policy question, Lauren?
Yeah, so I think I'd say I want to separate out two things. The production fee that was brought up earlier, that's something that is very much set by statute, and we don't have discretion to say how it's going to be applied. So my understanding is that that is going to be applied to all operators across the board. What I think your question was more getting at is cumulative impacts and the application of the rules. And I think on the one hand, everybody is required to comply with the rules. We can't, unless folks apply for a variance or something like that, we can't, exempt a smaller operator from compliance. But as some folks have talked about on other panels today, every application is individual. And I think that's going to be especially the case when it comes to a cumulative impacts analysis, because they're very, it's a lot of narrative summary talking about your specific operations in your specific location. So I don't know that I can say that small operators and large would be treated differently, but I think it's fair to say that every application will be treated based on its own merit and what's being proposed. Don't know if that exactly answers your question, but hopefully that's helpful.
Thank you, Lauren. I think we have another question back here.
Thank you. Wendell Kuntz, Delta County again. It's been said that God gave me the right to remain silent, but evidently not the ability. So, my question is, again, regarding renewables. I did a little Google research. To produce 3.6 gigawatts of energy using a conversion factor of 32.66 megawatts per acre, that's 110,000 acres. ECMC has done a very good job in regulating the oil and gas industry. And I guess my question is, particularly in cumulative impacts regarding this kind of land use, what would you say is best practices for local governments, local agencies to do to monitor and regulate cumulative impacts for these renewable industrial sites?
That's a really good question and a thoughtful one. Not an easy one to answer. But I think we did put a lot of work into these rules that are going to inform our approach to regulating cumulative impacts. And it was a really long stakeholder process. For years, we've been talking to local governments, industry, environmental groups, citizen groups, to try to get all the voices in the room and make sure our approach, while working within the bounds of what we have to do under the law, also takes into account as many different voices and opinions as possible. So I think, perhaps that can be a model for local governments as you're considering, if you're looking at your own kinds of regulations or process for examining cumulative impacts. I'd also point to Pete Dunleavy. Is he over there? So he is ECMC's new, I believe it's renewables coordinator, tasked or given the opportunity to work with local governments on issues around if you're creating your own codes for wind or solar. So I'd say talk to Pete would be the second part of my answer there.
All right.
Mimi, can I add just a note there? I appreciate the land use concern, and I just shamelessly will say, encourage your local governments to support oil and gas development. We've had incredible progress made in our efficiency and ability to extract these resources with lesser impact. And I look back, some of the first vertical wells I worked on to develop early in my career in mid-2000s were on 40-acre spacing, so 1 or 2 wells every 40 acres to get the minerals that lie under that section of land. We're working on a project now with roughly 30 acres of surface disturbance to access 6,400 mineral acres. So the technology, the efficiency, and the impact have all improved vastly over the last 2 decades. And we're still looking for ways to improve on that. I mean, as Katie mentioned, 3-mile laterals are becoming the norm, where the first DJ well I was involved in was about 4,000 feet. It took us 35 days to drill that well, and now we're drilling 13,000-foot laterals in 5 or 6 days. So the renewable industry may have its challenges, and I encourage you to keep finding ways to find improvements. But the oil and gas industry, we've actually met those challenges head on and found huge areas to improve. And I don't think we should let that go unnoticed.
Excellent comment. Thank you. Another question back here.
Tessa Sorensen, CDPHE. More question for industry. In terms of community engagement pieces, what resources have you had or are you now looking for or are sharing amongst your fellow industry folks in terms of community engagement on a level you were not used to, such as meeting them in their own language, bringing it down to plain language, all the experience that comes with that expertise in how to approach that?
Great question.
Thank you for the question, Tessa. And I don't necessarily know if I've got a good answer for you other than to say oftentimes it's trial and error until you find something that seems to work for your audience and for your stakeholders. It's pretty easy once you kind of lock in that formula to share it with your colleagues, regardless of who they work for or where their assets may be. It certainly is a challenge, and as I think everyone in this room will admit, the internet is a great thing, and it's also a not so great thing when you start Googling things and get 977,000 different answers to a single question. And so it's something that I think my panelists and I and the industry at large will continue to work together to find that formula that works best for all.
Thank you. Do we have one more question? Maybe not. All right. Well, we do have 2 minutes left for questions. I do see Kirby coming up the ramp. Any more questions out there? Okay.
This is Commissioner Jankowski, and I have another question, and maybe more of a statement. But when we're in Western Colorado, and you all more or less represent the eastern side of the mountains, and when you look at electrification, and that came from the Air Quality Control Commission, and you look at our hundreds of miles and our thousands, tens of thousands of acres that we cover, and it almost looks like you're trying to shut us down through midstream. And we have great midstream here. We can get our gas from east to west coast, and yet these rules and regulations are very punitive to us. And then when we go to cumulative impacts and we look at the communities that we are a DIC, and it is all of Western Garfield County is a DIC, and there's no population out there, but again, those rules hurt our industry, and they hurt. So I guess this is geared towards Lauren, and I know this come out of a legislature that is urban and believes in climate change, but it almost looks like you're trying to destroy the industry in Western Garfield, not Western Garfield County, Western Colorado. So it's more of a statement than a question, but I really, it upsets me as a county commissioner to have to see what's being done to our industry.
So if I could, thank you for that. And I understand it was more of a comment than a question, but I did want to make just one important clarification, which is the ESPs, or Enhanced Systems and Practices, we were talking about, which that's where electrification, pipeline takeaway, where that came up in conversation. Those are only applicable in the Front Range non-attainment area. So they do not apply at all out on this side of the state. So I definitely appreciate that there was more to your comment than just that, but wanted to make sure that that was clear to folks.
Do you want to talk about the DICs? Are you familiar with those in Western Colorado?
Sure, yeah, and you're exactly right that a lot of Western Colorado is one big DIC, and that is challenging, especially because a lot of the time that's rural area that there aren't a lot of people. And so I think the approach we took in the cumulative impacts rulemaking in terms of setting the higher bar for what operators have to do in DICs, it was tied to a higher bar for operations that are near residents in DICs. So there are more requirements for things like notice and community engagement and things like that if the well pad is within 2,000 or 4,000 feet of a residence in a DIC, instead of just being located out on open land that's also in a DIC. So we're definitely aware of the challenge that the DIC definition and maps creates, and did try to build in appropriate measures in the rules to not have that be punitive, or like you said, to stop development and kill the industry out here.
Thank you, Lauren, for that.
So with that, we're going to leave it there. A big round of applause for our panel.